मैं शुरू करता हूं, मुझे लगता है
हाँ शुरू करिए.
This is second class, and I've been directed to take 4 classes, this being the second one. Let's start forthwith. So it was crime, punishment, and sentencing that was the topic for the last discussion. क्राइम और पनिशमेंट के विषय में हम लोगों ने बात की थी, और द डिस्कशन वाज in the Indian perspective, because the topic in your syllabus is crime, punishment, and sentencing in Indian perspective. I had also discussed that can there be an Indian perspective different from the global perspective or international perspective as far as crime is concerned, as far as punishment is concerned. And we had not touched the aspect of sentencing in the last class. Therefore, when today I'll be speaking on the concept of death punishment, that is what your syllabus reads, I would certainly be starting with sentencing in Indian perspective. In the last class, I had hoped that it would be some interactive kind of a session or a dialogue between you as a group and me as a facilitator as far as this discussion is concerned. But that didn't happen. I hope that in the remaining classes, we are still left with 2 more classes, excluding today's. So I look forward to your active participation and engagement in the discussions, and I would also like you to engage me and to enrich me with your opinion. If you have a different opinion altogether, that would be something really great if that happens. पनिशमेंट को लेकर के हम लोगों ने जो चर्चा की थी पिछली क्लास में, तो मैंने बताया था आपको कि वी हैव इन आईपीसी वी हैव अ separate chapter on punishment, and that chapter on punishment has largely remained unamended. Largely remained because whatever amendments have been effected, whatever amendments have been made, they are only ornamental and not of much consequence as far as punishment is concerned. So you can count the punishments prescribed under the IPC, or for that matter any other penal legislation, be it special law or be it local law, on fingers. You have, for example, death penalty, you have life imprisonment, you have imprisonment which is of 2 kinds. One is with hard labor, that you call rigorous imprisonment. The other is without hard labor, and that you call simple imprisonment. The other form of punishment that you find in most of the penal provisions, almost every penal provision, is the punishment of fine, and the least that you would, I think, see, meaning thereby one of the most infrequently prescribed punishment is that forfeiture of property. Now, these are the only punishments that are permissible under the criminal justice system that we practice in this country. And don't get swayed by certain observations or certain so-called innovative punishments that the Supreme Court might have might have given in some rare cases. That is not the idea of punishment. When we talk about punishment, we talk about what has been prescribed by the legislature, and this is what the statute prescribes and what is awarded by the trial court. Every criminal case would have its origin in either a magistrate's court or in a sessions court, depending upon the nature and severity of that particular offense. You know the procedure, and it's the trial court that awards these punishments. And certainly there are rules, there are provisions, the processes and the procedure prescribed in the CRPC, including the jurisdiction of the different courts, which form a hierarchy within a sessions division. So when we talk about punishment, we talk about what has been prescribed by the legislature, what has been prescribed by the statute, and what the court awards is a sentence. If you are confused, let me make things clear at the very outset, and then we'll be talking about sentencing in Indian perspective. Now you have the offense of theft defined in section 378. I'll be focusing on Indian perspective. It's not necessary that I talk about the global perspective or a comparative perspective, though I may be referring to certain other jurisdictions, especially when it comes to sentencing in India and the problem that the Indian criminal justice system has been facing, and problems that the Supreme Court and many a times the high courts have identified as far as sentencing in India is concerned. Now you have the offense of theft, the simplest offense of theft, of course, defined in section 378 of IPC, and for that you have the punishment prescribed. When you look at the scheme of punishment for the offense of theft, you have 3 years imprisonment. 3 साल की सजा हो सकती है. 3 साल की सजा हो सकती है. Now, who prescribed this? Of course, even a beginner would tell that the makers of IPC, the legislature, prescribed this 3 years. But would every thief be punished with this 3 years imprisonment? क्या प्रत्येक चोर 3 वर्ष की सजा का भागी होगा? अगर किसी व्यक्ति ने चोरी की है तो उसका प्रोसिक्यूशन होगा, जिसको हम कहते हैं कि पनिशमेंट प्रोविजन के अंतर्गत होता है. लेकिन क्या आप ये कह सकते हैं by looking at the statutory provision that every thief, every pickpocket, हर एक जेब कतरा 3 साल की सजा का हकदार होगा, क्योंकि 3 साल की सजा लिखी हुई है. And that marks the difference between punishment and sentencing for an uninitiated or for a beginner, for a layman. That is the difference. Punishment hai 3 saal. The decision that what would be the appropriate quantum of punishment, whether it would be 3 years, whether it would be 2 years, whether it would be just 1 year, whether it would be even lesser, is part of what we call sentencing. Prescribing punishment is the prerogative of the legislature. What is the appropriate punishment? Within that prescribed limit is the prerogative of the court. So punishment is prescribed by the legislature and an appropriate sentence is awarded by the court, the judiciary, including the lower judiciary, of course, within that limit which has been prescribed by the legislature. Take another example, I think more जिसके विषय हम लोग जा रहे हैं कि जितना भी डिस्कोर्स है पनिशमेंट पर इंडिया में, जो भी डिस्कोर्स है, जो भी राइटिंग्स हैं, एकेडमिक राइटिंग्स, स्कॉलरली राइटिंग्स, judicial opinions that you have, in speeches of jurists, including judges, that they often deliver in programs and events, seminars and symposia and conferences and other events. They revolve around डेथ पेनल्टी. पूरा का पूरा जो डिबेट चल रहा है हिंदुस्तान में और बहुत सालों से जो चल रहा है वो डेथ पेनल्टी के इर्द गिर्द चल रहा है. एंड द जुडिशियल डिसीजंस, juristic writings, expert opinions, other discourses, they also rake up only one issue when it comes to punishment and sentencing, that is the punishment of death penalty and the sentencing process. As if there is just one punishment which should concern which should draw our attention, which should concern our judges, which should concern our academicians, which should concern our students of criminal law and other stakeholders. That's why I told you that let me take that example then to drive home the point that how punishment and sentencing are related and are to be understood in proper perspective. Look at the punishment for murder. You have section 302 of IPC which prescribes a punishment for murder, and everyone knows that it's either death penalty or life imprisonment. Either death penalty or life imprisonment. But you know that every murderer is treated differently. Every murderer is treated differently. And this led to formulation of a sentencing policy, or rather sentencing guideline. I won't look into the merits of that at this juncture as far as that sentencing guideline is concerned for awarding death penalty. But that guideline is for whom? And the guideline has been prescribed by whom? The guideline has been prescribed by the Supreme Court. Remember what the Supreme Court said in a majority decision in Bachchan Singh versus State of Punjab. Bachchan Singh, very well-known decision. In fact, every discourse on death penalty in India starts with Bachchan Singh, where the Constitution bench of the Supreme Court though it's not a unanimous judgment. That is also something that we'll be talking about shortly. But laid down what we call a sentencing policy for death penalty. What you call the doctrine of rarest of rare. The doctrine of rarest of rare. The doctrine of rarest of rare is the guiding light. What are the flaws as far as doctrine of rarest of rare is concerned? Whether that doctrine is appropriate, whether that doctrine is flawless, whether that doctrine is properly understood, whether that doctrine is something that could be implemented without any error, is something that we'll separately discuss if time permits later on. So you have the punishment for murder in section 302 of IPC, but the sentencing guidelines are there. In Bachan Singh, in Machi Singh, in many other cases, Kachanov decisions are there, where some or other sentencing guidelines have been issued. But then, as I already said, that it seems that the Indian society, the Indian judiciary, the Indian legal fraternity, the academia, everyone is so obsessed with death penalty that we have not given due attention to other punishments, and lack of any sentencing guideline or sentencing criteria as far as those punishments are concerned. Those criteria, those guidelines, so-called, vis-a-vis other punishments, they are not consistent, even if they are. For example, let's get back to the illustration, that instance, that example of the offense of theft. Theft attracts a maximum of 3 years imprisonment. Theft simpliciter, not the aggravated forms of theft. There are many in IPC. Theft simpliciter, that attracts a maximum punishment of 3 years. But I told you that every thief would not be getting 3 years imprisonment. Some would be getting 1 year, some would be getting 2 years, some would be getting 3 years, some would be getting only 1 month or so. So how and on what ground the court decides the quantum of punishment has remained a very perplexing issue. And lack of coherent sentencing policy, or lack of coherent sentencing guidelines has been ruled by the Supreme Court on several occasions, as far as Indian perspective is concerned. So this term sentence in law refers to punishment that was actually ordered. So you may have different sentences for the same offense. As I already stated, that every thief would not be getting 3 years imprisonment, every murderer would not be getting life imprisonment, every murderer would not be getting death penalty. So it's the punishment that was actually ordered by the trial court in a criminal procedure. This is what you need to first keep in mind. Now, as I already said, that we have a chapter on punishment in IPC. You won't find in any other legislation a separate chapter on punishment, because what the IPC prescribes is followed by other special or local legislations. Meaning thereby, these punishments which you find prescribed in section 53 are the punishments which in all future legislations the parliament or the state legislature is going to prescribe for different offenses. And this statement is true of the existing legislations as well. But why is a punishment imposed? Why is a punishment imposed? Probably in the last class I had told you that one distinguishing feature between what we call civil wrong and criminal wrong is that criminal wrong attracts punishment. And punishment is a measure that is adopted and enforced by the state. It is imposed by employing coercion and against the will of the accused, against the will of the culprit. And as I already mentioned, and the cost of repeating must state, that punishment can only be imposed by a competent organ of the state. Only a competent organ. And that competent organ is, the judiciary in our case. Prescription by the legislature, imposition by the judiciary. But why is punishment imposed? Why is punishment imposed? The same set of facts may give rise to both civil and criminal action. Criminal action, as you are aware by now, would lead to imposition of punishment. Because a criminal by his act causes loss to the society. That loss may be loss of peace, that loss may be the loss of order in the society. A theft in my neighbor's home would certainly breach my peace of mind that I'm also a likely target of theft. And it's the direct loss has been suffered by my neighbor. So why should I worry? Because I have not been affected by that. I have not lost my property on account of that theft. But certainly, there is a loss that has been caused to the society. You feel insecure even when you read in other parts of your state or in the country. So a criminal by his act causes loss to the society, and when he has caused loss to the society, he has therefore to pay back something to the society, and that is extracted from him by punishing him. Extracted. Kya de raha hai is par? He has to pay back. He has to pay back. There are many theories. Why do we punish? Why is punishment imposed? Why do we punish? Utilitarian theory is there. Utilitarian theory of punishment. Free will theory of crime. Free will. You chose to commit crime. As a person who is competent to exercise his free will, his volition, and must be held accountable for the loss that you have caused to the individual and also to the society. And that is why you are punished. The other theories as well. Other theories. So let me repeat that a criminal by his act causes loss, injury, harm to the society, and must be held accountable for that loss. And holding an accused accountable is sign of sovereignty. Only a sovereign state can do that. And the state and only state has the monopoly in imposing punishment. So when you look at the scheme of punishment in the IPC, scheme of punishment, मैंने बता दिया आपको, गिने चुने punishment, गिने चुने punishment. Or for that matter, the scheme of punishment in any other statute, special or local, you find that these punishments are not in sync with the modern trends. So what these modern trends are? Rather, they are almost redundant, obsolete. What is the modern trend? The object of punishment in present times has become correctional. And as a matter of fact, sentence should be properly measured by the judiciary so that the purpose of punishment is not lost. What is that purpose of punishment? Which should not be lost. Unfortunately, the Indian criminal law views punishment as an end unto itself. Punish karna hai. We have to punish. And punishment is seen as an end. This is contrary to the modern penological philosophies where punishment is seen only as a means to an end. And that end is the reform of the convict. So what you call penology is essentially the science of sentencing. It's science of sentencing. And as I already said that, leave aside if you keep the discussions, debates, writings, discourses on death penalty at arm's length, you have very little to study as far as sentencing in India is concerned. Very little to study. And then Supreme Court in 2008, I would request every one of you to read that judgment. 2008 का judgment है. The state of Punjab versus Prem Sagar. Probably the only judgment delivered by the Supreme Court where the Supreme Court seems to be greatly concerned about sentencing, not punishment. Punishment is a concern of the legislature, I already told you. Sentencing is the concern of the judiciary. Sentencing is the concern of the court. So the Supreme Court said, and it would be very apt if I may quote extensively from that decision. Prem Sagar state citation. Let me check the citation. Yes, it's a 2008 decision. 2008 7 SEC 550. 2008 7 SEC 550. So Supreme Court says this in 2008 and even in 2022. The observations that the Supreme Court made have not become redundant, have not lost their relevance. So Supreme Court says that presently there are no set principles of sentencing in India, and this has given rise to anomalies. And made several observations. A few I'm going to present before you, quoting straight from the judgment. The Supreme Court said that the Indian judicial system has not been able to develop legal principles as regards sentencing. Judicial system has not been able to develop legal principles as regards sentencing. And this is exactly what I was trying to tell you, that how sentencing belongs to the judges, to the court. Punishment belongs to the parliament, the legislature. So the Supreme Court goes on to add that the superior courts, except making observations with regard to purport and object for which punishment is imposed upon an offender, have not issued any guidelines. पनिशमेंट क्यों देना चाहिए, आप पढ़िए, थ्योरी की बात करते हैं, रिट्रीब्यूटिव है, डिटरेंट है, रिफॉर्मेटिव है, ऑब्जेक्टिव ऑफ पनिशमेंट, परपोर्ट एंड ऑब्जेक्ट. व्हाट इज द परपोर्ट एंड ऑब्जेक्ट? ये बातें करते हैं जजेस अपने डिसीजंस में. बहुत सारे, अभी मैं आपको सैकड़ों ऐसे डिसीजंस बता सकता हूं जिसमें उन्होंने डिफरेंट ऑब्जेक्टिव्स की बात करी हैं, डिफरेंट परपोर्ट की बात करी है. लेकिन they have not issued any guidelines, and this is in stark contrast to what is happening elsewhere in other jurisdictions, and this is highlighted by the Supreme Court in the state of Punjab versus Prem Sagar. Other developed countries have done so. At some quarters, serious concerns have been expressed in this behalf. Some committees, for example, the Madhava Menon Committee, Malimat Committee, have advocated introducing sentencing guidelines. Introduce sentencing guidelines. What should be the guiding principles? Sentencing guidelines. आपको याद होगा, मैं एक एग्जांपल और आपको देता हूं. I think you would be able to connect to that. You would be able to recall that. Prior to 2013, amendment in IPC, especially in the punishment for sexual assault, that is rape, that is section 376 of IPC. You knew that a statutory minimum sentence, a statutory minimum punishment was prescribed. That was 7 years. That was 7 years. But it was also provided that for special and adequate reasons, the court may award less than that statutory minimum without any further guidance in that statute. And rightly so, because a decision on sentence is something that the judge has to take, the court has to take, in the peculiar circumstances of the crime and also in the peculiar circumstances in which the criminal is. Circumstances of crime, circumstances of criminal, circumstances of the victim, other attending circumstances. But there was no coherent principle that was evolved. Coherent principle. And there are catena of decisions. आप pre-2013 के decision देखिए, या 2013 के amendment के बाद भी वो decisions देखिए हाई कोर्ट्स के, सुप्रीम कोर्ट के, जिनमें punishment to see unamended या pre-amendment provision में दिया गया. Supreme Court has come down heavily on several high courts, that how can you consider this as a reason sufficient to reduce the sentence or award the sentence less than a statutory minimum, less than a statutory minimum. तो उन्होंने कहा कि ये रूरल बैकग्राउंड से आता है, पढ़ा लिखा नहीं है. रूरल बैकग्राउंड से आता है, पढ़ा लिखा नहीं है. इज दैट अ ग्राउंड sufficient enough to award less than statutory minimum?
No, sir.
And this is what the high courts have done in this country on several occasions. Several occasions. Poverty, as far as property offenses are concerned. Poverty may be a factor in deciding the quantum of punishment. In case of theft, simpliciter, poverty. Certainly someone who commits theft for greed and someone who commits theft for need, or because he is needy, he has no other means, the state has failed to provide him 2 square meals for him, for his family, must be dealt with leniently. And this latitude is available within the provision of punishment. But can poverty be a reason for reducing punishment in case of rape? Of course, poverty can't be a reason for committing that offense. When poverty can't be a reason for committing that offense, how can poverty be a reason for reducing that sentence below statutory minimum? So this lack of coherent sentencing guidelines led to prescription of minimum mandatory sentences in many cases. Minimum mandatory sentences were unheard of in IPC. IPC में minimum mandatory sentences जो हैं वो unheard of थे, गिने चुने offenses में. आप कहेंगे minimum mandatory किन offenses में? तो एक एग्जांपल तो आपके पास मर्डर का ही है, मिनिमम मैंडेटरी सेंटेंस. मिनिमम मैंडेटरी क्या है? लाइफ इंप्रिजनमेंट है भाई, क्योंकि दो ही सेंटेंस हो सकते हैं, या तो लाइफ इंप्रिजनमेंट होगा या डेथ पेनल्टी होगी. तो मिनिमम मैंडेटरी तो लाइफ इंप्रिजनमेंट है. मिनिमम मैंडेटरी, कम से कम लाइफ इंप्रिजनमेंट मिलेगा, अधिक से अधिक डेथ पेनल्टी मिल सकती. But minimum mandatory sentence was not a norm. Minimum mandatory sentences were only exceptions. And see the developments that have taken place post 2013. Now you have now several scores of offenses, newly introduced in 2013, or the already existing offenses have now been amended. Punishment part has now been amended to introduce minimum mandatory sentence only because the courts failed in their duty to quantify and appropriate a punishment in the given circumstances. रुचिका गिरोत्रा एक केस था, आपने शायद नाम सुना होगा. अनफॉर्चुनेट, वेरी वेरी अनफॉर्चुनेट इंसिडेंट. रुचिका गिरोत्रा, all of 15 years, and a very promising lawn tennis player. She was in fact subjected to sexual harassment, molestation by none other than a very highly placed police officer in Chandigarh. The offense under which that officer was tried, IPS officer, he was her grandfather's age at that particular point in time when he had done that. 15 साल की बच्ची और ये 50 साल के आसपास के थे, इनका प्रोसिक्यूशन हुआ 354 आईपीसी में, आउटरेजिंग मॉडेस्टी. It's another matter that Ruchika Girotra later committed suicide. The case dragged on. Ruchika Girotra came from a very humble background, and it was difficult for her family and uh, those who supported to fight this uneven battle. Would you believe that when the accused was tried and was sentenced, the maximum punishment for the offense under section 354 of IPC was 2 years imprisonment. 2 साल की सजा हो सकती थी, मैक्सिमम 2 साल की सजा हो सकती थी, and the judge chose to award only 6 months imprisonment. Is there any reason that you can think of for choosing this quantum of punishment? Shouldn't the punishment be exemplary in such cases? Shouldn't he be made an example for the like-minded people, the potential molesters and criminals who are all around us? And that probably led the legislature to now prescribe a mandatory minimum. आप देखिए 354 में 2013 में mandatory minimum sentence आ गया कि किसी को भी दे. Now desirability, constitutional sort of issues, constitutional principles, whether constitutional principles allow this. What about the freedom of judiciary? What about you have tied the hands of the judiciary that सबको 1 साल तो देना ही देना है, उसके ऊपर आप जो prescribed limit है उसमें दे दीजिए. Many times it is argued that this is unconstitutional. That's another debate. That's a different debate altogether. कैनाडियन सुप्रीम कोर्ट ने कहा है, अमेरिकन डिसीजंस हैं जहां पे उन्होंने कहा कि स्टैट्यूटरी मिनिमम सेंटेंसेस जो हैं वो अनकॉन्स्टिट्यूशनल. इंडिया में क्या हो रहा है? इंडिया में statutory minimum sentences have become norm in IPC. You would find that there are now multiple provisions where you have the statutorily prescribed minimum mandatory sentence which the judge must award in every case, and the discretion would now be available to choose that what additional punishment or should be given. What should be given in addition to what is prescribed now by the legislature as mandatory minimum. स्टेट ऑफ पंजाब वर्सेस प्रेम सागर में फिर से मैं पढ़ रहा हूं, आपको बता रहा हूं स्टेट फ्रॉम द जजमेंट. The Supreme Court went on to add that whether the court, while awarding a sentence, would take recourse to principle of deterrence or reform or invoke doctrine of proportionality would no doubt depend upon the facts and circumstances of each case. What should be the guiding principle? What should be the guiding objective? Deterrence होना चाहिए, reform होना चाहिए, या जिसको जस्ट डेजर्ट्स कहते हैं वो होना चाहिए. द डॉक्ट्रिन ऑफ प्रोपोर्शनैलिटी. सुप्रीम कोर्ट कह रहा है प्रेम सागर के केस में कि वुड नो डाउट डिपेंड ऑन द फैक्ट्स एंड सर्कमस्टांस ऑफ ईच केस. बट देन it added that while doing so, however, nature of offense plays an important role. The offenses which affect public health must be dealt with severely. It went on to add in State of Punjab versus Prem Sagar. There are certain offences which touch social fabric. Even while introducing doctrine of plea bargaining, CRPC, certain types of offences have been kept out of its purview. While imposing sentences, the said principle, or rather principle, should be borne in mind. You know that plea bargaining was introduced as a measure to lessen the burden on the trial courts. 265A, आप याद करिए, CRPC. But when you look at the scheme of plea bargaining, you would find that certain offences have been kept out of the purview of plea bargaining. बच्चों के खिलाफ जो ऑफेंस हुए हैं, महिलाओं के खिलाफ जो अपराध हुए हैं, जिन अपराधों को हम सोशो इकोनॉमिक ऑफेंसेस कहते हैं, जिनको फाइनेंशियल क्राइम्स कहते हैं, ऐसे अपराधों को प्ली बार्गेनिंग के दायरे में नहीं रखा गया है. ऐसे अपराधों को प्ली बार्गेनिंग के दायरे से बाहर रखा गया है. Why? Because the legislature viewed these offenses differently and more seriously, and the intention was to punish them with the highest possible severity, because in the opinion of the legislature, such offences harm the social fabric of the society. उसी जजमेंट में, प्रेम सागर के जजमेंट में, सुप्रीम कोर्ट ये भी कहता है कि what would be the effect of sentencing on the society is a question which has been left unanswered by the legislature. What would be the effect of sentencing on the society is a question which has been left unanswered by the legislature. मैं थोड़ा सा डिफर करता हूं. लेजिस्लेचर को ये लगता है कि डेथ पेनल्टी इज आंसर टू ऑल द इल्स दैट इज प्लेगिंग द इंडियन क्रिमिनल जस्टिस सिस्टम. डेथ पेनल्टी इज द आंसर. डेथ पेनल्टी इज द आंसर. So the number of offences in IPC that would attract death penalty has only increased in the past decade or so. पिछले 10 वर्षों में अगर आप 2013 से 2022 के बीच में अगर आप लीगल डेवलपमेंट देखें तो आप पाएंगे कि द नंबर ऑफ डेथ पेनल्टी इन आईपीसी, मैं अन्य अपराधों की बात ही नहीं कर रहा हूं, मैं अन्य कानूनों की बात ही नहीं कर रहा हूं, you would find that the number of death penalty has only increased. For example, now you have death penalty even if the victim of rape survives but has been reduced to persistent vegetative state. You have death penalty if the victim is under the age of 12 years. Possibility of death penalty? No. That was something unheard of. Death penalty for murder, death penalty for causing death was the norm. Death penalty किस अपराध के लिए थी? Death penalty थी though Mahatma Gandhi's mantra was that an eye for an eye, a tooth for a tooth would make the entire world blind. But still, we had death penalty. And this that an eye for an eye would make the whole world blind, because vengeance never works. Vengeance never works. And death penalty is nothing but a vengeance of the state. बदला जिसको कहते हैं, बदला. And it's barbaric as well. Barbaric because you derive pleasure as a society in someone's death, which is irreversible. तो वो कहते हैं कि प्रेम सागर के केस में सुप्रीम कोर्ट कहता है कि इफेक्ट ऑफ सेंटेंसिंग on the society has not been answered by the legislature. Effect of sentencing on society has been answered by the legislature. और आंसर है कि yes, the most deterrent in the opinion of the legislature is death penalty. Death penalty never deters people, because death penalty is reserved, as you know, for the most heinous offenses, and those who commit most heinous offenses are the most fearless people as far as death penalty is concerned. I don't think that anyone who has decided to kill would be deterred by death penalty. अब आप कहेंगे कि फिर रास्ता क्या है, उस पर भी हम लोग चर्चा करें. But the Supreme Court notices in Prem Sagar case that the superior courts have come across a large number of cases which go to show anomalies as regards the policy of sentencing. Yes, I already talked about. Whereas quantum of punishment for commission of similar type offences varies from minimum to maximum. Even where some sentence is imposed, the principles applied are found to be different. Similar discrepancies have been noticed in regard to imposition of fine. Though यहां तक कि आप इसको हम इम्प्रिजनमेंट या पनिशमेंट ऑफ इम्प्रिजनमेंट कहते हैं, उसमें तो एनोमलीज हैं ही, उसमें तो इनकंसिस्टेंसीज हैं ही. प्रेम सागर में सुप्रीम कोर्ट कह रहा है कि फाइन लगाने में भी आप जो है वो बहुत inconsistent ho, especially in those cases where the amount of fine has not been prescribed. And most heinous crimes, in most serious crimes, you will find that the amount of fine has not been prescribed. It's only prescribed that shall also be liable to fine. और दूसरा, to what extent should the judges have discretion to reduce the sentence so prescribed under the statute has remained a vexed question. It's not an easy question, especially in those cases where statutory minimum sentence has been prescribed, with a proviso that in cases where the court finds that there are special and adequate reasons, it may award less than the statutory minimum. तो यहां पर क्या कोई प्रिंसिपल है, एक थंब रूल है, और उस पर हम लोग बात करेंगे. In India, the view has always been that the punishment must be proportionate to the crime. Punishment must be proportionate to the crime. अब ये proportionate क्या है, ये कभी कभी प्रॉब्लम पैदा करता है. क्या proportionate है? किसी के लिए रेप जो है वो मर्डर से भी ज्यादा हीनियस ऑफेंस है, किसी के लिए मर्डर से ज्यादा हीनियस ऑफेंस कुछ नहीं. So some would argue that no, death penalty for rape is an appropriately proportionate sentence. Some would argue that even for death, even for murder, death penalty is not an appropriately proportionate sentence. That's highly disproportionate, and imposition of death penalty can never be justified. Jury is still out. और सुप्रीम कोर्ट भी इसको एक्नॉलेज कर रहा है प्रेम सागर के केस में. उन्होंने कहा कि the view always has been that punishment must be proportionate to the crime, but applicability of the said principle in all situations is open to question. तो अब वो ये कह रहे हैं बाद में, towards the end, that judicial discretion must be exercised objectively, having regard to the facts and circumstances of each case. Objectively तो करेंगे, but having regard to the facts and circumstances of each case, it means that it has to be objectively subjective. And then the Supreme Court exhorted the courts in India to adhere to certain basic norms in awarding an appropriate sentence. तो ये sentencing policy होनी कैसी चाहिए? And when I am talking about sentencing policy, certainly I'm not talking about death penalty as yet. I'm talking about sentencing policy in general, excluding sentencing policy for capital offenses where death penalty may be awarded. So it has been observed that sentencing policy needs to strike a balance between two sides and count upon the twin tests. What are those twin tests? One is deterrent effect. The second is complete reformation for integration of the offender in the civil society. और ये भी जरूरी है कि where the court is satisfied that there is no possibility of reforming the offender, the punishment for that offense and punishment before all things must be befitting the nature of crime and deterrent with an explicit aim to make an example out of the evildoer, the offender, and a warning to those who are still innocent, but everyone is a potential criminal, especially in certain situations. You know that this situational criminal or this theory, this theory of situational criminal that has gained currency in modern times. So when it comes to sentencing in Indian perspective, I would say that there is hardly any sentencing guideline. Even in the most interesting thing is that even in Prem Sagar case, you would find that there are no guidelines issued by the Supreme Court, though the Supreme Court has lamented the fact that ऑब्जेक्ट पनिशमेंट का क्या होना चाहिए इस पर तो बड़ी बड़ी बातें की गई हैं, लेकिन किसी में किसी डिसीजन में गाइडिंग प्रिंसिपल्स क्या होने चाहिए इस पर बहुत बात नहीं की गई है. लेकिन सेंटेंसिंग पॉलिसीज होनी चाहिए. अब ये सेंटेंसिंग पॉलिसीज बनाएगा कौन? क्या जुडिशरी को बनानी चाहिए या क्या लेजिस्लेचर को बनानी चाहिए? शुड देयर बी स्टैट्यूटरी सेंटेंसिंग गाइडलाइंस? दिस अगेन अ वेरी vexed question. One view is that evolving and formulating sentencing guidelines should be left to the judiciary, because what is an appropriate sentence in the given circumstance can only be decided by the judiciary, and the legislature can't foresee all the future cases, and it would be disastrous for administration of criminal justice if there are statutorily prescribed sentencing guidelines that are binding on the courts. But then there is this school of thought with many supporters, and of course I would cite one example from England and Wales, a country from whom we derived our criminal justice system or our legal system, that what is happening there as far as sentencing in different offenses is concerned. So there is no doubt that question of sentence is a matter of discretion. तो मैं बता रहा था कि एक दूसरा जो स्कूल है वो ये कहता है कि नहीं, courts have failed as far as appropriate quantification of sentences concerned, and when they have failed, and in a country like India, there is a great deal of inconsistency. Therefore, it's good that the legislature steps in and prescribes sentencing guidelines which are binding on the courts. कुछ भी हो, ये कहना होगा कि क्वेश्चन ऑफ सेंटेंस इज अ मैटर ऑफ डिस्क्रिशन, देयर इज नो डाउट, बट the said discretion cannot be used by a court in a fanciful and whimsical manner. So when we say that the matter is within the discretion of the court, it is to be exercised according to well established judicial principles, according to reason and fair play, and not according to the whims and the caprices of the judge. ये ऑब्जर्वेशन तो एक जनरल ऑब्जर्वेशन है. इट अप्लाइज टू exercise of judicial discretion in order of appropriate sentences in criminal trials as well. एक नया केस मुझे मिला था, आप चाहें तो आप पढ़ सकते हैं if you have time. R. Sasikala versus State of AP. Ravada Sasikala, Ravada Sasikala versus State of AP. Ravada Sasikala versus State of AP जो है वो 2017 का डिसीजन है, बहुत नया तो नहीं है, बट स्टिल आफ्टर प्रेम सागर विच इज ऑफ 2008 decision, certainly it brings some newer perspective. Rather, it reiterates few things which we have already discussed. So Ravada Sasikala versus State of AP में on sentencing policy, the Supreme Court made certain observations, and I must present before you those observations, not in exactly the same language, but let me try. Supreme Court ने ये कहा कि sentencing for any offense has a social goal. उसका एक सामाजिक उद्देश्य होता है. Sentence is to be imposed, regard being had to the nature of the offense and the manner in which the offense has been committed. The fundamental purpose of imposition of sentence is based on the principle that the accused must realize that the crime committed by him has not only created a dent in the life of the victim, but also a concavity in the social fabric. The purpose of just punishment is designed so that the individuals in the society which ultimately constitute the collective do not suffer time and again for such crimes. It serves as a deterrent. ये 2017 में सुप्रीम कोर्ट जो है वो कह रहा, और वो आगे वो कहते हैं कि on certain occasions opportunities must be granted to the convict for reforming himself, but it is equally true that the principle of proportionality between an offense committed and the penalty imposed are to be kept in view. अब ये कह तो रहे हैं प्रोपोर्शनलिटी, प्रिंसिपल ऑफ प्रोपोर्शनलिटी, प्रिंसिपल ऑफ प्रोपोर्शनलिटी, लेकिन यही तो सबसे बड़ा सवाल कि व्हाट वुड बी द प्रोपोर्शनेट सेंटेंस. तो सुप्रीम कोर्ट कहता है कि पर्पस पे बात करता है इस केस में, शशिकला के केस में, that punishment is designed to protect the society by deterring potential offenders, as also by preventing the guilty party from repeating the offense. It is also designed to reform the offender and reclaim him as a law-abiding citizen for the good of the society as a whole. वो कहते हैं कि मल्टीपल ऑब्जेक्टिव्स है. कोई ये ना समझे कि पनिशमेंट का एक सिंगल ऑब्जेक्टिव या दंड का एकमात्र उद्देश्य जो है वो डिटरेंस है. या दंड का एकमात्र उद्देश्य जो है वो प्रिवेंशन है, या दंड का एकमात्र उद्देश्य जो है वो वेंजेंस है। उन्होंने कहा कि डेटर करिए, प्रिवेंट करिए और रिफॉर्म भी करिए, रिफॉर्म भी करिए। अब आप जब सेंटेंसेस को देखते हैं अपने आईपीसी में, तो आपको मुझे बताना होगा कि देयर इज वेरी लिटिल एज फार एज रिफॉर्म एज एन ऑब्जेक्ट, रिफॉर्म एज एन ऑब्जेक्ट इज कंसर्न। तो हम लोग बहुत जल्दी से आज प्रिंसिपल ऑफ जस्ट डेजर्ट्स, और व्हाट in many cases the Supreme Court has referred to as principle of proportionality पे थोड़ी सी बात कर लेते हैं। just deserts is a philosophy of justice whereby an offense is viewed as lowering the victim or community's status or power that is relative to the offender, which requires a degradation of the offender to redress the moral balance. However, just desert means to ensure that a punishment is both appropriate to a crime and that it is consistent. Someone who steals a loaf of bread certainly does not deserve life imprisonment, and one who brutally kills for greed can't be let off with fine alone. किसी ने चोरी कर ली because he had no other means to sustain himself and to provide for his family and all. Should he be most severely punished? And someone who has committed murder for greed, आप जब डेथ पेनल्टी पे हम लोग बात करेंगे तो हम लोग देखेंगे हाउ murdering for greed has been viewed very, very seriously, even in Bachchan Singh's decision, in Machi Singh's decision, in later decisions. There are many cases where people were awarded death penalty because they committed brutal murders for greed of hapless and helpless victims. So should they be let off with fine alone? उनको तो फाइन केवल लगा करके कि नहीं इन्होंने ग्रीड के लिए किया था इसलिए इनके ऊपर 5 लाख रुपए का जुर्माना लगाते हैं और उनको छोड़ दिया जाए. No, I'm not advocating death penalty in every such case, but still, whatever punishment is most severe under the existing system of punishment should be reserved for the most serious offenses. That is the principle of just deserts or proportionality. So simply put, punishment for a crime should be proportionate to its gravity. Simple. It is the duty of the court to choose an appropriate punishment for the crime in question. And proportion between crime and punishment is a goal that is respected in principle, and in spite of errant notions, it remains a strong influence, very, very strong influence in determination of an appropriate sentence. Several cases, Supreme Court has cautioned the judges. For example, in Bablu versus State of Rajasthan, जो है वो Bablu versus State of Rajasthan, let me check which year. Bablu versus State of Rajasthan जो है वो मुझे लगता है कि 2006 का डिसीजन है. बबलू वर्सेस स्टेट ऑफ राजस्थान आप पढ़ेंगे अगर तो उसमें आप देखेंगे कि हाउ सुप्रीम कोर्ट हैज कॉशन्ड द जजेस टू चूज एन एप्रोप्रिएट पनिशमेंट keeping in view personality of offender and circumstances, situations and reactions. Death penalty पे ही है तो death penalty पे ही, but still I think the observations that have been made by the court, they would apply to all other offenses. So in that case, in Bablu, the Supreme Court said that the principle of proportion between crime and punishment is a principle of just deserts that serves as the foundation of every criminal sentence that is justifiable. तो ये कहते हैं कि एज अ प्रिंसिपल ऑफ क्रिमिनल जस्टिस it is hardly less familiar or less important than the principle that only the guilty ought to be, हम लोगों ने पढ़ा है ना, only the guilty ought to be punished, only the guilty ought to be punished. उन्होंने कहा कि ये प्रिंसिपल भी उससे कम फेमिलियर नहीं है. And the requirement that the punishment should not be disproportionately great, which is a corollary of a just desert, it's dictated by the same principle that does not allow punishment for the innocents. For any punishment in excess of what is deserved for the criminal conduct is punishment without guilt. वो ये कह रहे हैं कि डिसप्रपोर्शनेट जो पनिशमेंट है, डिसप्रपोर्शनेट, हाईली डिसप्रपोर्शनेट, दैट इज tantamount टू पनिशिंग समवन विदाउट गिल्ट. अब आप चोरी के लिए आजीवन कारावास की सजा अगर प्रेस्क्राइब कर देते हैं और जज साहब लोग जो है वो 10 साल 12 साल 15 साल सिंपल थेफ्ट के लिए देने लगते हैं, तो दैट इज हाईली डिसप्रपोर्शनेट, नो डाउट अबाउट इट. So there have been numerous cases where the Supreme Court has discussed this principle of proportionality. For example, in Guru Basav Raj versus State of Karnataka, Guru Basav Raj versus State of Karnataka में Supreme Court discussed the concept of appropriate sentence and said that it is duty of the court to see that appropriate sentence is imposed. Regard being had to the commission of crime and its impact on the social order. The cry for justice, which includes adequate punishment, can't be lightly ignored. Principle of proportionality, as followed in various judgments of the Supreme Court, prescribes that the punishment should reflect the gravity of the offense and also the criminal background of the convict. Graver the offense and longer the criminal record, the more severe is the punishment to be awarded. You know that. Now you have many offenses in IPC where repeat offenders would be more severely punished, and certainly it's not the object of reform that guides the courts in choosing appropriate punishment in case of repeat offending, because by repeat offending the criminal has exhibited or has shown that he is beyond reform. So one who is beyond reform must be made an example for the like-minded people, and deterrence can be the only object of punishment. Similarly, in corruption cases, in high offices, there are plenty of observations of the Supreme Court of late. Supreme Court ने कहा ये रिफॉर्म बेकार है. Those who commit corruption in high offices, they are beyond reform. So reform can't be the object of punishment. It can only be deterrence. It can only be preventive. Deterrence so that others are deterred. Preventive so that he again is not in a position to commit that offense. एक चीज आपने गौर की होगी कि जब पनिशमेंट का ऑब्जेक्ट की बात कर रहा है सुप्रीम कोर्ट, तो वो बार बार कह रहा है कि सोशल इम्पैक्ट ऑफ द क्राइम शुड बी टेकन इनटू अकाउंट. It should be seen that whether the offender by his act breached the social fabric or has harmed the social fabric. ये कह रहे हैं कि undue leniency in awarding sentence should be avoided as it does not have necessary effect of being a deterrent for accused and does not reassure the society that the offender was properly dealt with. Social impact, whether society's cry for justice has been responded adequately, is what the Supreme Court said that should be the object of punishment. Societal interest in protection from crime should be strengthened through deterrence, is what the Supreme Court has said of late. तो रिफॉर्म पर थोड़ा कम फोकस दिख रहा है, रिफॉर्म पर थोड़ा सा कम फोकस दिख रहा है, और सुप्रीम कोर्ट ये कह रहा है कि सोसाइटल इंटरेस्ट इन प्रोटेक्शन फ्रॉम क्राइम शुड बी स्ट्रेंथेंड थ्रू डेटरेंस. आप डेटर करिए. डेटरेंस का मतलब है कि यू आर मेकिंग दैट offender that convict a criminal. और बहुत सारे केसेस में सुप्रीम कोर्ट ने कहा है जस्ट पनिशमेंट इज द कलेक्टिव क्राई ऑफ द सोसाइटी. जस्ट पनिशमेंट, अब ये बड़ा ऑब्जेक्टिव है. जस्ट व्हाट इज द जस्ट पनिशमेंट? व्हाट इज द जस्ट पनिशमेंट इज फॉर द जज टू डिसाइड, लेट मी टेल यू, इन द एप्रोप्रिएट केसेस. But while the collective cry has to be kept uppermost in the mind, simultaneously the principle of proportionality between the crime and punishment can't be totally brushed aside. The principle of just punishment is the bedrock of sentencing in respect of a criminal offense. This is how I'm concluding my discourse on sentencing here. So I was talking about lack of coherent sentencing guidelines and who should frame these guidelines, judiciary or the legislature. And I told you that there are two models. One is the Indian model where the courts have done, even if they have done very little, this job of constitutional courts of formulating sentencing guidelines. The other one is where pre-devised guidelines have been there, meaning thereby guidelines are there, and those guidelines have been issued by what we call in England and Wales sentencing council. And this sentencing council, if you read or visit that web page that is dedicated to sentencing council, was a body, is a body that was set up in April 2010 to promote greater transparency and consistency in sentencing while maintaining the independence of the judiciary. Now this is very interesting objective, क्योंकि जब सेंटेंसिंग गाइडलाइंस की बात होती है और ये बात होती है कि कोई स्टैट्यूटरी बॉडी बना दी जाए जो सेंटेंसिंग गाइडलाइंस इशू करे और उन सेंटेंसिंग गाइडलाइंस को एडहियर करे जुडिशरी, तो इसका ऑपोजिशन इस आधार पर होता है कि दिस इज एन अफ्रंट ऑन द इंडिपेंडेंस ऑफ जुडिशरी. बट द सेंटेंसिंग काउंसिल क्लेम्स दैट वी आर अ बॉडी सेट अप इन 2010 and the mandate is to promote greater transparency and consistency in sentencing while also maintaining the independence of the judiciary. And the primary role of the council is to issue guidelines on sentencing which the courts must follow unless it is in the interests of justice not to do so. Meaning thereby, even when this statutory body in England is issuing guidelines, and they have plenty of guidelines available for the sentencing courts, right from the magistrates court up to the higher courts. There may be occasions where a court refuses to follow these guidelines and is allowed to do so if the interest of justice so so demands. तो ये जो सेंटेंसिंग काउंसिल है, इसका क्रिएशन जो है वो कोरोनर्स एंड जस्टिस एक्ट 2009 जो इंग्लिश पार्लियामेंट का लेजिस्लेशन है उसके अंतर्गत हुआ था. एंड दिस काउंसिल इज अकाउंटेबल टू द secretary at the Ministry of Justice. This is part of, though independent, but is part of Ministry of Justice, and they have many educational and insightful videos available on their website. तो आप अगर सेंटेंसिंग काउंसिल, केवल सेंटेंसिंग काउंसिल इन यूनाइटेड किंगडम, ये गूगल अगर करेंगे तो यू वुड फाइंड very good material available there. Certain videos, very short videos, 3 मिनट 4 मिनट 5 मिनट के videos जो हैं वो available है. Let me see if I can play one. I don't know, so that we देखता हूँ, otherwise we are done for today. I'm not able to play that, so I'm done for today. If you have any question or if you want to make any comment or any intervention, you are welcome.
सर, माय नेम इज मोनाश्री. बस एक सिंपल सा क्वेश्चन ये था कि प्ली बार्गेनिंग का यूज अभी कितना होता है सर? अभी तो वो जिस ऑब्जेक्ट से वो इनैक्ट किया गया था उसका यूज तो होता नहीं उतना.
बिल्कुल सही है. इनफैक्ट अगर आप प्ली बार्गेनिंग की हिस्ट्री पढ़ेंगे हिंदुस्तान में, तो सुप्रीम कोर्ट के कुछ डिसीजंस हैं, ठीक है, जिसमें सुप्रीम कोर्ट ने, जब ये स्टैट्यूटरी प्ली बार्गेनिंग नहीं थी इंडिया में, तो उसके पहले के सुप्रीम कोर्ट के कुछ डिसीजंस हैं जिसमें सुप्रीम कोर्ट ने कहा था कि प्ली बार्गेनिंग इज एंटीथेटिकल टू पब्लिक पॉलिसी. ठीक है. तो एक माइंडसेट बना हुआ है इंडियन जुडिशरी में बहुत पहले से कि प्ली बार्गेनिंग इज समथिंग वेरी बैड. ऑलराइट, एक तो पहला ये कारण हो गया. इवन आफ्टर द स्टैट्यूटरी स्कीम ऑफ प्ली बार्गेनिंग वाज इंट्रोड्यूस्ड, देयर आर मेनी हर्डल्स, and I think this is not the right forum to discuss all that. Attitude of the lawyers, attitude of the judiciary, the trial judges, attitude of the high courts, attitude of the Supreme Court is collectively responsible for the failure of this system of plea bargaining in this country. और आपकी बात बिल्कुल सही है कि plea bargaining couldn't take off in India, but the idea is good. तो प्ली बार्गेनिंग बहुत मुश्किल है. आपका जो डिफेंस लॉयर है वो जब आपसे ये कहता है कि हम तो अक्विटल करा देंगे आपका, तो फिर आप तैयार होंगे क्या प्ली बार्गेन करने के लिए? वो कहता है कि नहीं मैं तो अक्विटल करा दूंगा, मेरा जुगाड़ है, मेरे कनेक्शंस हैं. झूठ बोलते हैं. बट दिस इज हाउ, सो यू आर नॉट वेरी मच इंक्लाइंड. वो कहते हैं नहीं प्ली बार्गेनिंग मत करो, उसमें सजा होनी है ना, थोड़ी सी तो कुछ ना कुछ तो होगी. प्ली बार्गेनिंग आप करेंगे तो छूट तो जाएंगे नहीं. इट्स नॉट कंपाउंडिंग, इट्स डिफरेंट. और वो ये कहते हैं कि अरे कुछ नहीं होता है, मैं देख लूंगा, यू वुड बी एक्विटेड. और भी है रीजंस हैं. प्ली बार्गेनिंग में बहुत ज्यादा जो जुडिशियल मैजिस्ट्रेट्स थे वो भी इंटरेस्टेड नहीं थे. थिंग्स हैव चेंज्ड, things are improving, but it would still take a lot of time before plea bargaining gets accepted in the legal fraternity as a good measure. Yes.
सर जो पुलिस का रोल होता है इसमें प्ली बार्गेनिंग तो वो वहीं पे स्टार्ट कर देते हैं एट द स्टेज ऑफ फर्स्ट
नहीं नहीं, वो
इंफॉर्मेशन
नहीं कर
रिपोर्ट
सकते। नहीं
एज
नहीं नहीं, उसको आप नहीं नहीं, वो प्ली बार्गेनिंग की वो स्टेज नहीं है। प्ली बार्गेनिंग
सर
की स्टेज, प्ली बार्गेनिंग, वो प्ली बार्गेनिंग देखिए विदाउट मैजिस्ट्रेट्स this supervision, or it can only be presided over by the magistrate. तो उसके बिना हो नहीं सकती। उसको भाई जाहिर सी बात है, वो पुलिस वाले मीडिएशन करते ही हैं, उसको प्ली बार्गेनिंग के कॉन्टेक्स्ट में या उसके उसमें देखने की जरूरत नहीं है। वो चाहते हैं कि ये मामला जो है वो कोर्ट तक ना पहुंचे।
वहीं पे सॉल्व हो जाए, वहीं पे कॉम्प्रोमाइजिंग लेवल पे ही सॉल्व हो
हाँ
जाए।
बिल्कुल, दैट्स नॉट प्ली बार्गेनिंग, वो प्ली बार्गेनिंग नहीं।
ओके
टेक्निकल जो प्ली बार्गेनिंग है वो दैट इज समथिंग इंटायरली।
ओके सर, थैंक यू सर।
So let's call it a day, and we'll meet tomorrow at 10 again.
Okay,
I'll
sir.
be talking about death penalty in particular. Today I was talking about sentencing in general. So death penalty in particular, and then one more topic would be left, that is criminal justice in India, administration of criminal justice from a primitive era to postmodernism, and that is what we'll do. Thank you.